This presentation discusses the remedies, penalties, and enforcement in Minnesota's Data Practices Act and open meeting law. We will first discuss the remedies, penalties, and enforcement related to the Data Practices Act, which is located in Minnesota Statutes, Chapter 13. The first type of remedy in the Data Practices Act for violations of the law is a civil lawsuit. This means that a person who suffers damages as a result of a violation can sue the government entity or responsible authority for any damages, plus court costs and reasonable attorney's fees. A person can ask a district court judge to issue an injunction, which is an order requiring the government entity or responsible authority to stop violating the law. Entities and responsible authorities must comply with these court orders. Finally, a person can bring an action in district court to compel a government entity to comply with the Data Practices Act. A judge may include a penalty of up to $1,000 if he or she issues an order compelling compliance. A person may recover litigation costs and attorney's fees if the judge decides it's appropriate. Any person who is found to have willfully violated the Data Practices Act is guilty of a misdemeanor. A finding of a willful violation is also just cause for a public employee's suspension without pay or dismissal. A person can file an action to compel compliance with the Data Practices Act at the Minnesota Office of Administrative Hearings. A $1,000 filing fee is required. If the person substantially prevails in the action, the $1,000 filing fee must be refunded and the office's costs must be billed to the entity found in violation of the law. If an administrative law judge, or ALJ, determines a complaint does not adequately allege a violation, it must be dismissed. If an ALJ determines a complaint does allege a violation, he or she must schedule a hearing on the matter. Following a hearing, the ALJ must determine whether there was a violation and do at least one of the following: dismiss the complaint, find a violation, impose a civil penalty, issue an order compelling compliance with the law, or refer the complaint for criminal charges. Upon request, the Commissioner of the Department of Administration has the authority to issue a written advisory opinion relating to specific areas. The Commissioner's authority is discretionary, which means he may choose which requests to accept. The areas the Commissioner may address in an opinion include access to government data, the rights of the subjects of government data, and how the law classifies government data. A requester must be notified within 5 business days if the Commissioner will not issue an opinion. Opinions that the Commissioner accepts must be issued within 50 days of the request. The Commissioner's opinions are unlike court orders or court decisions because they are not binding on a government entity. However, a judge must give an opinion deference in a proceeding that involves the data. There is no state agency that is able to enforce the provisions of the Data Practices Act. The Commissioner of Administration, Data Practices Office, or the Attorney General do not have the legal authority to investigate complaints or force anyone to comply with the law. The Office of Administrative Hearings has some authority to compel compliance with the law, but an order from an ALJ must be enforced through the district courts. Ultimately, only a district court has authority to order compliance with the law and issue civil penalties and award costs and attorney's fees. A request to charge someone criminally must be made to the appropriate prosecutorial authority, which would generally be a city attorney with authority to prosecute misdemeanors. We will now move on to the remedies, penalties, and enforcement in Minnesota's open meeting law, Minnesota Statutes, Chapter 13D. A member of the public may bring a lawsuit against any person who commits an intentional violation of the open meeting law. If the court finds there has been an intentional violation, the person is subject to a personal liability of $300 per violation. If the person is found to have violated the law in 3 or more actions relating to the same body, he or she must forfeit the right to serve on the body for a term equal to the term of office. Parties may also receive costs and attorney's fees for findings of intentional violations, up to $13,000. The public body may recover attorney's fees if the court finds that the lawsuit was frivolous. The court may also award attorney's fees to the plaintiff where the public body was the subject of an advisory opinion about the issue being litigated and the body did not act in conformity with the opinion. The Commissioner of Administration has the authority to issue non-binding advisory opinions on open meeting law issues in the same manner as data practices opinions. The biggest difference is that open meeting law opinions cost $200. The Commissioner's authority to issue an opinion relates to a public body's duties and compliance with the law. Unlike data practices opinions, in a legal proceeding involving the performance of duties under Chapter 13D, a judge must give deference to an advisory opinion on the same subject involving the same parties. Even though the Commissioner's opinions are not binding, a member of a public body will not be liable for attorney's fees or subject to forfeiture of office if he or she acts in conformity with an opinion. As with the Data Practices Act, no state agency is able to enforce the provisions of the open meeting law. The Commissioner of Administration, Data Practices Office, or the Attorney General do not have the legal authority to investigate complaints or force anyone to comply with the law. Ultimately, only a district court has authority to find an intentional violation of the law and issue civil penalties and award costs and attorney's fees. Thank you for viewing this presentation on remedies, penalties, and enforcement in the Data Practices Act and open meeting law. For more information, please visit our website.